My name is Frasia Kendrick, and on behalf of United Benefit Advisors and Fisher Phillips, I would like to welcome you to today's presentation in the UBA Employer Webinar Series. Today's topic is HIPAA, Privacy and Security, what employer plan sponsors need to know. Our speaker today is Carl Pilger. Carl is of counsel in the Atlanta office of Fisher Phillips and a member of the firm's Employee Benefits Practice Group. He advises clients with respect to all aspects of employee benefits and executive compensation with an emphasis on health and other welfare benefit plans, cafeteria plans, consumer-driven healthcare options, and employee wellness programs. So I'm going to go ahead and turn it over to Carl. Thank you all for coming.
Frasia, thank you so much for the introduction. Welcome, everybody. Thanks for the opportunity to speak today. And we will jump right into our topic, which will be HIPAA, privacy and security. And will be a bit of a refresher at the outset. We'll talk about all the ins and outs of exactly what we need to know and exactly why we need to know it. The sort of 5 W's of all of the HIPAA privacy and security rules. We'll talk about what PHI is, how to protect it, what exceptions there are to its use. Under the privacy rule, we'll talk about the security rule and those elements that need to be implemented by employer plan sponsors in order to make sure that electronic or ePHI is properly secured. We'll talk a little bit about why it all matters from the standpoint that it can result in some very costly penalties if you have HIPAA compliance failures. Do a little overview of OCR enforcement activity and talk at the end about some tips and best practices so that we can all remain compliant, avoid investigations, and carry on our merry way in full compliance with HIPAA. So as a refresher, let's talk a little bit about what it is we're talking about. And that, of course, is overall the Health Insurance Portability and Accountability Act of 1996. Essentially, it had 2 components. The first of which everybody was dealing quite a bit with initially at its outset when the law was first passed, and it had to do with portability and non-discrimination and implementing rules that you couldn't discriminate against folks because of health status factors and things of that nature. You'll also recall that prior to the ACA passage and the change on pre-existing conditions, there were creditable coverage certificates and other elements of Title I of HIPAA that helped people be able to make their coverage portable and prevent what was perceived to be a large part of being locked into a particular job with no ability to move. So that was Title I of HIPAA that was intended to address those types of issues. Title II, which they somewhat ironically, I think, called administrative simplification, because it certainly didn't simplify the lives of those who run plans, run medical practices, or advise either of those groups on how to comply with HIPAA. But that's where we find in that administrative simplification portion of HIPAA, the privacy and security rules that we will be talking more about as we move through today's presentation. Several years after the passage of HIPAA, we also had the Health Information Technology for Economic and Clinical Health Act of 2009, which is a mouthful, but which is reduced down to the acronym HITECH, and the omnibus rule. And those rules were put into place to add certain provisions, expand on other elements of protecting ePHI under the HIPAA security rule, and also changed the nature of the game with respect to business associates and the fact that they could then be, after the passage of these rules, directly liable for violations of HIPAA, as opposed to being secondarily liable in a sense that the plan sponsor would be liable, and then per the contract with the business associate, the plan sponsor could chase down that third-party business associate. Now, under these rules, business associates take on their own liability. These rules also gave us what we know today regarding breaches of PHI and what to do to respond to a breach, how to correct breaches, how to identify what a breach actually is, and some of the things that we'll talk about later today. And then also implemented some of the enforcement mechanisms for the protection of PHI under both the privacy and security rules. So in a nutshell, again, as by way of refresher and summary, remember that HIPAA, which protects PHI, is aimed at covered entities, and covered entities are either group health plans, healthcare providers, or healthcare clearinghouses. Group health plans, and we'll talk a little bit more about this, need to be concerned, and those types of plans that should be concerned with the HIPAA rules would include standard group medical plans, dental plans, vision plans, health FSAs, certain EAPs. Again, whenever we're talking about an EAP in the context of ERISA, we have to remember that EAPs that are purely referral only type EAPs generally are not deemed to be health plans because they're not providing anything in the nature of substantive healthcare or health-related services. But if you have an EAP that actually does provide for counseling and so on and so forth, provided by medical practitioners within the EAP, those types of EAPs would have HIPAA concerns, whereas the strictly referral type EAPs would not. When we talk to a lot of our employer clients, they kind of believe, if they haven't been knee deep in the hoopla with respect to HIPAA, they kind of believe that sort of anything that we learn anytime, any data about any of our employees is all covered by HIPAA. We have to remember that there are certain things that an employer will do and certain HR functions that will occur that actually are not covered by HIPAA because they don't relate to the group health plan. So when we're talking about things like workers' comp or life insurance or disability or leaves of absence or some of those other things that we in the HR and the workplace world have to deal with regularly, even though there may be some type of health information that falls out of having to handle one of these other types of situations, because it's not part and parcel of the group health plan itself, it is not subject to HIPAA because it isn't coming from or being used by the group health plan, which is the defined covered entity for HIPAA purposes. Also remember that certain smaller health plans, if self-funded and self-administered, would be excluded from some of the requirements we're talking about today. Healthcare providers, of course, those are the ones who are going to transmit health information in an electronic form with respect to transactions involving medical care and treatment. They would be covered entities. They have their own set of rules that we're not going to jump into today. We'll keep our focus with group health plans. And then healthcare clearinghouses, as defined under the statute, also would need to worry about this. Now, remember, too, and it's in red, italicized print here because it's an important distinction, there is a misconception that employers themselves are covered entities. And we have to remember that the employer functions two ways, or wears two hats, as we sometimes say, that there are a number of things that an employer will do as the employer that, again, are not subject to HIPAA. However, the group health plan, and therefore the things that the employer might do as the sponsor of that plan, those are the types of things we're talking about. So it's an important distinction, and sometimes it's hard to conceptualize. But when we have someone that says, well, I'm an employer, so therefore I'm subject to HIPAA. Well, you technically are not, as an employer, subject to HIPAA, but the group health plan that you might sponsor is subject to HIPAA, and it has the compliance obligations which you would necessarily, of course, sort of fulfill on its behalf. Business associates. Again, we mentioned earlier that under the high-tech rules, and as we have gone through time with HIPAA, business associates now have direct liability for violations of the law. A business associate, of course, is someone who performs a function for a covered entity, provides specific services to the covered entity, in our case, services to the group health plan, and in doing so, gains access to, has the ability to access individually identifiable health information. Examples of this that I'm sure we're all familiar with would be a third-party administrator, or perhaps an attorney, or your broker, an actuary or accountant, basically anybody that's going to be, again, providing services to help in the day-to-day administration of a group health plan, to the extent that anything they do on behalf of the plan gives them this access to this sensitive information, then they are a business associate, and they would need to have a business associate agreement, which we'll talk about in a moment. And they would need to be wary of the fact that they could be subject to liability if they don't follow all of the HIPAA rules that apply. Remember that insurance companies, carriers of fully insured plans and HMOs are not business associates of the employer. They are, in fact, deemed to be a covered entity of themselves, which is why they have obligations under HIPAA themselves, in addition to the obligations that the health plan has. So that is a distinction that's important to understand vis-a-vis who is a business associate. As I mentioned a moment ago, the key and critical point of identifying your business associates is that there is an obligation under the HIPAA rules regarding privacy that if you have a business associate, you must also have a written business associate agreement, or a BAA, in place with each and every business associate who, again, is providing services to your group health plan, and as a part of providing those services has access to PHI. Remember that a BAA itself is a binding contract. It outlines and defines the particular liability and responsibilities of the various parties to that contract regarding how they manage, how they handle PHI, including or electronic PHI, and the other various HIPAA requirements that would apply to that relationship and to the services they provide to the plan. HIPAA requires that there be certain elements contained in a business associate agreement. We refer to those sometimes as the required contract requirements. And there is a sample or a template it's dated, but it still has all of the necessary contract requirements in it that can be accessed via the HHS website. And there are other resources out there, but that's one that definitely can provide a sample of what a business associate agreement should look like in general. To the extent that it may have been a while since you may have looked at your business associate agreements that have been in place for some time, or maybe you have entered a new relationship with somebody that's going to be providing services to your plan for the first time. It's a good time. It's always a good idea to review on a periodic basis the third-party service providers, determine who has access to PHI, determine in fact if a business associate agreement is actually required due to the nature of whatever that relationship is and whatever services are being provided, and to ensure that existing business associate agreements meet all of the various requirements under HIPAA. Sometimes, as we mentioned a minute ago, a slide or two ago, identifying who the business associates for your plan can be a sticky wicket. That can be something that gets a little dicey. We've developed sort of a decision tree, if you will, that we'll walk through here in the next couple of slides that will allow you, on behalf of your group health plan, which again is the covered entity, to determine, again, who is a business associate. In general, you can see here that as you move down the chain, you as the covered entity, the group health plan, needs to have a contract or a BAA in place with any business associate that you directly contract with to provide services. That business associate may, depending on the nature of what they do and the services they provide, they may have a subcontractor that's going to perform a certain number of or portion of the services that the plan contracts with that business associate to provide. And therefore, they're going to need a separate business associate agreement with their business associate subcontractors. As you can see from this diagram, the covered entity is not responsible for going around and under the business associate with whom it has a BAA to also then maintain a separate BAA directly with a particular subcontractor. But it's imperative that you make sure that your business associate agreement properly notifies the business associate that to the extent that it is going to sub out any of the responsibilities it has to your group health plan, it then needs to have its own agreement with that subcontractor that contains all of the relevant terms out of the business associate agreement they have with you. So The liability goes down each layer. Each contract passes through each layer, but the covered entity doesn't need to go and get separate agreements with any business associate subcontractors that might be performing services. I mentioned a little while ago that we've developed a simple methodology that one can walk through to figure out who is actually a business associate with respect to the plan. And the primary question, of course, is protected health information, or PHI. That individually identifiable information regarding treatment of an individual covered under the plan, is that being disclosed to a person other than in the capacity as a member of the covered entity's workforce? So there may be information that is going to be disclosed necessarily to the folks working for the plan within your organization. Those folks working in your organization are not business associates. They are actually part of the plan itself. So it's only if you're saying, am I disclosing information to a person or entity that's outside and is not a member of my workforce? If the answer to that is yes, we move down. If the answer to that is no, then of course you don't need a business associate agreement with those folks who are internal to the plan. If you've identified folks who are external, who are getting access to PHI from the plan, is that PHI being disclosed to a healthcare provider for treatment purposes? In other words, is information being given to a primary or referring physician, contracted physicians or specialists, nurses, rehab staff, an ambulance company, so on and so forth? If the answer is yes, and it's being just given to a healthcare provider, then that healthcare provider is not a business associate and does not need to have a business associate agreement with the plan. If it's someone other than healthcare providers providing treatment to plan participants, then we drop down to the next level and we need to determine, is that PHI being disclosed to the health plan for payment purposes or to a health plan sponsor with respect to disclosures by a group health plan? If the answer is yes, again, no business associate agreement is needed. However, if that PHI is being disclosed outside of the organization to someone who is not a healthcare provider treating a participant, and it's not for payment purposes or with respect to disclosures, then we would move to the next level. And we would ask if the PHI being disclosed to a government agency pursuant to an official investigation, because again, those governmental agencies are not business associates. If that's the case, no business associate agreement is needed. If not, then we drop down and is the PHI being disclosed to another covered entity that is part of an organized healthcare arrangement? So if you've got related covered entities, all part of one organized arrangement as defined under HIPAA, then those related entities do not need business associate agreements with each other. If again, it's going somewhere else, not part of an organized healthcare arrangement, then we would drop down and we'd say, okay, does the person or entity create, receive, maintain, or transmit PHI for a function or activity that's regulated by HIPAA? So claims processing, data analysis, processing or administering the plan, utilization review or UR, quality assurance, patient safety activities, billing, benefits management, or repricing. If the answer is yes, that person is getting, creating, receiving, or maintaining PHI from the plan for those purposes, then the business associate agreement is needed. Entities are specifically included under high tech, include health information organizations as laid out right there. You will also need to make sure you have a business associate agreement if a person or entity is providing legal, actuarial, accounting, or consulting services, data aggregation services, management, administration, or financial services, where the provision of those services involves disclosure of PHI to the person or entity. If that's the case, and they are going to get and PHI will be disclosed to them, then you're going to need a business associate agreement with them. If the answer is no, then the last question you ask to figure out whether this person who is getting access to PHI is, will another person or entity be able to access PHI on a routine basis? Or is there a possibility that the PHI in the person or entity's possession could be compromised? So for example, do you have information that's going to a data storage vendor, somebody that's supposed to be destroying or shredding information so on and so forth. And the answer to that is yes, then you should have a business associate agreement with them. If they're not able to access PHI on a regular routine basis, and there's not a possibility that the PHI is going to be compromised, then you don't need a business associate agreement. So again, each relationship is going to be different depending on your plan, depending on the services that you contract to have provided to your plan. But in a nutshell, this process is what you would work through these 3 slides here, and you should be able to arrive at whether or not you need a BAA to be in place. Remember, again, we talked about benefit plans that have to have or that are covered and subject to HIPAA, and that would include individual plans providing medical care. We've already sort of talked about some of the things that we would generally have a concept. Of course, medical, dental, and vision plans, but remember health flexible spending arrangements. There are no exceptions for government or church plans, as there are for certain elements of ERISA. There's no exception under HIPAA for those types of plans, so they are covered by HIPAA. Certain wellness programs, medical services related to employee discounts, retiree health plans, and on-site medical clinics, again, drawing a distinction similar to what we talked about with EAPs, which is examining the on-site medical clinic to determine whether or not it's actually providing significant health services, or if it's just doing something more routine than if it's, depending on the nature of the medical clinic, it may or may not have more significant HIPAA requirements on it. Sorry, something funny has happened to my screen. Okay, supplemental benefits, cancer insurance, hospital indemnity, cafeteria plans, so on and so forth. Coverage essentially depends in certain cases on whether these plans provide medical care and whether or not they are maintained by an employer. If they provide medical care and are maintained by an employer, then we've got obligations to worry about. And if they are not, then we don't have to worry about it. When we talk about group health plans, we talk about two types. We've got fully insured and self-funded. And there's, again, a misconception, I think, in many cases where individuals have either heard or believed that if I'm fully insured, meaning I provide a group health plan, but it's contracted out through an insurance carrier or an HMO, then I, as the plan sponsor, don't have any obligations with respect to HIPAA. And we'll talk a little bit about that's partly true, but it's not universally true. And just because you operate a plan subject to contract with an insurance carrier or an HMO doesn't mean that you're free and clear from all HIPAA obligations. And in particular, HIPAA security rule, when we get to talk to that. If you're self-funded, then it's a whole different issue, and you're definitely going to be subject to HIPAA. And we're going to talk a little bit about, if you're fully insured, when might it be that you can, quote unquote, take a hands-off approach, and maybe then, because you're only getting access to certain types of data, you might have fewer HIPAA obligations with respect to the HIPAA privacy rule. But again, you're not going to get out of obligations under the security rule that we're about to discuss. So if you have a fully insured plan, you could be exempt from certain privacy rule requirements, like adopting particular HIPAA private policies and procedures or delivering privacy notices, but only if you take a hands-off approach. To be hands-off and avoid most of the privacy rules administrative requirements, the group health plan has to provide benefits through a fully insured contract with either a carrier or an HMO, and the plan cannot receive or create PHI other than summary health information. And that summary health information is prepared and used for a limited purpose, for obtaining a premium bid, for example, or modifying, amending, or terminating the plan. If you're getting only summary health information and you're only using it for those limited purposes, then you could be hands-off and not have to worry about many of the privacy rules. The other element of this is enrollment data. If you get enrollment information to perform enrollment or disenrollment activities, including making certain payroll deductions for group health coverage, you can do all of that. So you can have access to enrollment information and still maintain this hands-off posture that takes you out of some of your HIPAA responsibilities. The privacy requirements in this case, if you're fully insured through a carrier or HMO, and you're only getting summary health information for bidding or altering or modifying your plan, or enrollment information and payroll deductions, then the privacy requirements are put onto the health insurer rather than the employer. So again, employers with a fully insured hands-off plan don't have to maintain or distribute a notice of privacy practices. That's why you'll oftentimes in the fully insured world, the notice of privacy practices is a document that's prepared by and distributed by the insurance carrier, not the plan sponsor. Now, having said this, there are ways that you can be hands-off, but it's a high threshold. It's a high bar. There's going to be many instances where a fully insured plan is going to access PHI, for example, helping to process participant claims, or you're operating an FSA or an HRA. And by virtue of doing those things and being involved in those types of activities, you're really not going to be able to make sure that you're hands-off. So it's a high standard, and you have to be careful not to get so involved in plan administration that you're getting PHI even unexpectedly, or where you may think that you're not, but you actually are. So if an employer wants to assist an employee, for example, with a claim, to remain hands-off, the employer has to make sure that it gets an authorization. If you get an authorization from the employee before obtaining any PHI, so you're directly engaged with the individual in trying to solve whatever claim issue they might have, and it's subject to their authorization, that's one way to make sure that when you're getting into claims assistance, you don't foul the water, so to speak, and take yourself out of a situation where you thought you might have been hands-off, when in fact you're now hands-on because you didn't go through this process of making sure that all your activity as far as claims administration or assistance is subject to and pursuant to a valid authorization from the individual. Now, remember that, again, FSAs and HRAs are kind of a unique situation. So even if you manage somehow to adopt a fully hands-off strategy with respect to your overall group health plan, and you're getting authorizations before you would do anything to assist anybody with a particular claim, you still could unwittingly become hands-on and subject yourself to all the things that you were trying to avoid under HIPAA if you're operating an FSA or an HRA. And that's largely because under the rules, FSAs and HRAs are deemed to be self-funded plans. And once you have a self-funded plan and you're involved in the operation or administration of that, it's no longer possible for you to meet the high standard of being hands-off. So just a word to the wise that if you operate one of those self-funded arrangements, either a health FSA or an HRA, and you think you're hands-off completely, that may be something to reevaluate. Now, self-funded plans generally cannot qualify for hands-off status, as we've said. That would be your FSAs and HRAs. There is an exception depending on the nature of the FSA, that if it's only for certain, or HRA rather, if it's only for certain accepted benefits, you may be able to still maintain a hands-off approach. We talked a little bit about employee assistance programs, but remember, again, if you're self-funded and your employee assistance program is, again, offering medical services, or you're self-funding a group health plan, or you've got a wellness program that is affiliated with and a component part of your group health plan, those are the types of self-funded arrangements that are going to put you squarely in the crosshairs of HIPAA, and you are going to have to comply with all of the HIPAA rules. Now, remember that there is that one exception we talked about. It's a limited exception for self-funded, self-administered plans. So nobody providing services to help administer the plan, and they have to be under 50 employees who are eligible to participate in that plan. So those types of plans, very small plans, self-funded, self-administered, wouldn't have to worry about the HIPAA privacy rules. However, remember that just because you're not subject to HIPAA, which is a federal privacy rule that relates to group health plans and PHI, you may be operating in a state that has implemented its own set of health privacy rules. And it's always important then, if you believe that you may be in this situation where you can avoid HIPAA, you have to make sure that you're not, again, unwittingly running afoul of some state law that would apply to operating that plan that would protect an employee's privacy with respect to their health information. And you would need then, of course, to understand what the various rules and requirements were of your particular state privacy law. So under the privacy rule, what do we talk about? What does HIPAA require? So remember that HIPAA is going to require certain notices and disclosures. You're going to generally, if you're subject to this rule, you're going to need a notice of privacy practices. And that's going to basically be a notice that gives everybody that is part of the plan, that's a participant in the plan, a clear understanding in plain English and plain terms of what their rights are with respect to their PHI and what the privacy practices are of the plan. There's a model notice available, again, on the HHS website. You can include it in your SPD. There are certain rules. People always say, well, in this day and age, can't I distribute everything that I have to distribute under whatever law it is that pertains to my plan? Can I do it electronically? And the answer, in short, is yes. With respect to this, you can do this electronically, but remember that the rules are a little bit more burdensome than they are under the standard ERISA or DOL document disclosure rules. And remember, too, that with respect to the notice of privacy practices, this is a type of notice that if your carrier is not providing it and you are in a position where you're subject to the requirement, you have to provide it to new enrollees at enrollment, and you have to send a reminder of what the notice of privacy practices is at least every 3 years. And if somebody comes to you and asks for a copy of your notice of privacy practices, you would need to provide it upon request from that individual. There's specific content, a specific format for the notice of privacy practices. Again, you're generally describing all the rights, duties, and responsibilities, the types of disclosures that are available or that will be made by the group health plan without an individual's authorization. And again, as we said, you need to give it to them at enrollment. Anytime it's revised and you make a material change, you would also need to provide that revised notice within 60 days of making that change. And you can post a copy on the intranet, but a paper copy also must be available to an individual upon their request. Again, we mentioned earlier, and we'll go into it a little more detail here to give you a little more background on the electronic disclosure requirements. So if you've got a notice of privacy practices and you want to distribute it electronically, that's fine. If the employer happens to have a website that gives information about the plan itself, you would need to prominently post and display the notice of privacy practices on that website and make it electronically available through that website. The employer can also provide it by email if an individual has agreed to electronic notice and that agreement has not been withdrawn. If there's also the idea that you kind of have to make sure that it gets where it's going. So if the employer knows that the email failed, then the employer should follow that email failure. If you get a bounce back message, you would need to get a paper copy to that individual to make sure that you fulfilled your obligation to provide it to them. Again, the participant has to get a paper copy of the notice if they ask for one. Keep a copy of the notice of privacy practices to document your compliance. This is the type of thing that if you were ever subject to the OCR or the DOL or somebody else, they have a right to ask for it, and you need to produce it in response to that request. And again, back in the day when this was all sort of new, there was a question as to whether or not you had to have a written acknowledgement that somebody got the notice of privacy practices. That still applies, but it only applies in the context of a healthcare provider. So if you go to your doctor or any other practitioner and they give you a notice of their privacy practices, you'll also sign something saying, I've been given a notice of my privacy practices, et cetera. That's not a requirement for group health plans. That's just a requirement on providers. So PHI, again, all of these rules regarding privacy and all the rules we'll talk about in a minute about security have to do with protecting PHI or protected health information. It's an individually identifiable information that is created by or received by a healthcare provider, a health plan employer, or healthcare clearinghouse, and it relates to the past, present, or future medical treatment of an individual, whether that's physical or mental health, the provision of any kind of healthcare to an individual, or the past, present, or future payment for the provision of healthcare to an individual, and the information has to identify that individual, or there's a reasonable basis to believe that the information could be used to identify the individual. So it relates specifically to an individual. It happens in the healthcare setting. It relates to either treatment or payment or provision of healthcare, and it does or could be used to identify a particular person. Individual information, essentially, it's identifiable. There are 18 specified identifiers that includes dates related to the individual, such as birth dates, zip codes, unique identifiers, obviously anything related to a social security number, so on and so forth. That's all the type of information that when we say it's individually identifiable. And again, the protections under the law go to any of that individually identifiable health information that's created or received by a covered entity or a business associate, again, relating to healthcare or payment for healthcare. And again, remember, that's the covered entity is the group health plan, not the employer itself. So in determining whether or not something is PHI or whether it contains PHI, and it's something that we have to apply these HIPAA rules to, we have to remember that doesn't include general employment records. So if you're an employer and you're dealing with your workers' comp program or your FMLA and leave absence management program, generally that's not PHI in the possession of the employer because it's not information that came from the group health plan. The covered entity, group health plan didn't create, isn't maintaining, so on and so forth, any of the information related to those other employer HR functions. So if it's unrelated to the health plan, generally that it would be excluded. So information about someone's medical condition that's relevant to their request to take a leave of absence or in processing a workers' compensation claim, for example, that's something completely different and isn't subject to PHI, which doesn't mean it's a free-for-all and we can just disclose that information as we choose to anybody. There are rules that would pertain to that. They're just not the HIPAA rules that we're talking about. You'd have to examine the records themselves to figure out whether it's an employment record versus a plan record. And remember that we will talk a little bit more in depth in a bit that protected health information would be information that would be stored in a paper format or somewhere in an office, and there are safeguards that need to be applied to that so that that information doesn't get into the wrong hands. But we're also going to talk about ePHI, which is PHI that gets stored or transmitted electronically. Okay, remember that summary health information, we talked about that before. It's the type of information that an employer plan sponsor can get and still be hands off. It's info that essentially summarizes a claims history or expenses or types of claims by individuals enrolled in a group health plan and has most of any of those individual identifiers removed. So it doesn't include names or addresses. It doesn't include full zip codes. It doesn't include birth dates, phone numbers, any kind of email addresses, anything that again could be used to identify an individual, such as social security number, even a medical record number or an account or plan participant number, any vehicle identification numbers, or any photographs or other biometric identifying information. If all of that type of information is not included and the information is general and it's just a summary of claims and expenses, and it doesn't, therefore I can't use it and I can't get back to who it came from or who it relates to, then that's summary health information. And that summary health information isn't subject to these rules. De-identified information has all specific identifiers removed and is therefore also not considered individually identifiable health information. So the privacy rule has specific guidance as to what constitutes de-identified information. That essentially, again, there's two methods by which you could de-identify information, and one requires removing all specified identifiers and not having actual knowledge that the information could be used either alone or in combination with other information to identify an individual. And the other opinion, the other method requires an expert opinion that the risk is very small that the available information could be used to identify a particular individual. Again, it's important that when we're dealing with PHI, you should limit PHI and its distribution or its use or its disclosure to folks to the minimum amount necessary for an individual who needs it for their function to perform that function. So if you've got somebody within your organization that, for example, is helping somebody with one particular element of one particular claim, you wouldn't want to give that person a full file of every single treatment and all kinds of information related to the individual. It would just be the minimum amount necessary and the limited PHI that relates to that particular issue. Remember that PHI can be used or disclosed without an authorization for treatment purposes, payment purposes, healthcare operations, which involves things like quality oversight review, legal services, audit functions, and so on. Other disclosures to the individual business associate or as required by law, and in particular emergencies. If you have any of these bullet points, the first 5 bullet points here, then the law provides that those types of uses and disclosures can be made without an authorization. If, however, it doesn't fall within one of these categories, then it is going to be subject to an authorization requirement before it can be used or disclosed. So remember, we talked about it earlier. If I have the need to use PHI and disclose it for one of the purposes that isn't listed here, I can do so, but I have to get an authorization from an individual first. There are rights and rules under the HIPAA privacy rules that give individual certain protected rights. They have the right to receive privacy notices. We've talked about that a little bit before. They have the right to inspect and copy their own health information. They have a right to request that that information be amended. They have the right to request that it be restricted, that the confidentiality of that health information be limited to only being disclosed to certain individuals, for example. They have the right to receive an accounting of anything that is not a routine disclosure of health information. They also have a right to file a complaint about any perceived privacy violation. So remember that those rights, that's sort of also what gets included in documentation regarding your privacy practices, so on and so forth. Remember, again, we mentioned it before, make sure that if you're disclosing information or your business associate is disclosing information, PHI, limit it to the minimum amount necessary for the function at hand. Only employees who need to know should have access. Identify ahead of time in your organization which employees are going to need access to PHI, and limit access only to those employees and only to the specific information that they need to do their job. Make sure that you've got policies and procedures in place that limit the disclosure to the amount and type necessary, and make sure that everybody is trained to understand what your rules are regarding fulfilling requests that would involve disclosure of PHI. I think the general rule of thumb, particularly as we talk about privacy and head into talking about security, is that you should understand and treat all of this information as top secret. You can see here we've got a folder with a lock, padlock on it. That's a visual representation of essentially saying anytime you've got information in your organization's possession, as far as operating and administering the group health plan, it should be essentially under lock and key, whether it's electronic information or whether it's hard copy. Moving on to the HIPAA security rule, you have to ensure under the HIPAA security rule that you maintain the confidentiality, integrity, and availability of all ePHI that the plan creates, receives, maintains, or transmits. You have to be able to protect it against any reasonably anticipated threat. Cybersecurity gets a lot of pub these days, and we talk a little bit about that in a minute, just regarding, being hacked, where are the vulnerabilities within my system where somebody could get access to ePHI that shouldn't have access to that ePHI. So that's part of performing a risk analysis, which you're required to do under the security rule. We'll talk about it in a minute, so that you can anticipate threats and stave them off before they occur. Again, under the security rule, the plan needs to protect against uses and disclosures of any ePHI that could reasonably be anticipated, and it needs to protect that information regardless of where within its systems ePHI is accessed. So PHI maintained using some kind of electronic storage media. That would include memory devices and computers. So that would include your hard drives on any of your desktop computers. It would include your laptop computers in the same vein. Any removable or transportable digital memory, like a magnetic disk or an optical disk, a thumb drive, some kind of other digital memory card, and PHI that would be transmitted via the internet or on an extra or intranet, or anything that's being transmitted across the lines that service your plan, and any private networks that are set up with respect to your plan. Remember that ePHI is all that stuff we just talked about. It doesn't include your voice over a telephone. It doesn't include fax or paper, because info being exchanged did not exist in an electronic form prior to its transmission by one of those means or methods right there. So that type of communication not subject to the security rule because it's not ePHI. Be cautious, be aware of items stored electronically, like voicemails and faxes that come in as email attachments. Those are because they have been transmitted electronically, you might take something that would not be considered ePHI, and now you've made it ePHI, again, because it's being stored and has been transmitted as an email attachment. HHS has published a helpful guidance to provide covered entities, including group health plans, with some information about what risks they need to protect against. Document an appropriate business case for remote access to a PHI, analyze and manage the potential risks and vulnerabilities associated with remote access using PHI from an offsite location. Include remote access provisions in your written HIPAA policies and procedures. Remember, training. Another important element of the HIPAA security rule is people have to understand what your rules are regarding ePHI, and they have to know how to implement those in their daily transactions and life with respect to how they use or access ePHI. And that is part of a comprehensive training program that's required to give individuals the information they know to make sure that they maintain compliance. Document the plan for any data breaches or security incidents, any other incidents of non-compliance that involves accessing, storing, or transmitting electronic PHI. These are the types of things that the DOL in particular issued some information last year to make sure that everybody is aware, hey, there are some best practices that you should implement to make sure that everybody in your organization knows not to do certain things with the electronic information that they might all of a sudden have access to on a tablet or a laptop or whatever it might be. And among those is identifying who is it that has access, what devices do they get access with, and how are we putting in processes and procedures to make sure that proper encryption exists, and that they're properly trained to know the do's and don'ts with respect to the ePHI that they are accessing or transmitting. And remember, a fully insured plan, like we discussed earlier, can be exempt from the privacy rule requirements, like adopting privacy policies and procedures and the delivery of the notice of privacy practices. But every single plan, fully insured or not, has to comply with the security rule. Remember too, that every company is going to be a little bit different. There's not one cookie cutter solution to this complying with the security rule. And you're going to have to work closely with your internal folks, especially your IT folks, for example. You're going to need to know, based on your size, your complexity, how much information you are transmitting electronically, what kind of technical infrastructure do you have, what are your various hardware and software parameters within your organization, so on and so forth, and what's the probability of a potential risk to that ePHI. Some of that, that's going to be, the C-suite folks are going to task your HR folks with figuring out this whole mess and what do we have to do to comply with it. But when we get to the security rule, you're necessarily going to have to get the IT folks on board. They're the ones that know how everything runs, how everything operates, what the system capabilities are, and they're going to be the ones that are going to help you identify what the risks and vulnerabilities are. And they're already doing that with your overall organizational IT cybersecurity policies. This is a subset of those, and this is sort of a separate beast, but they should be involved in it because they're going to be able to walk the walk and talk the talk and they're going to be able to help you establish the required security policies and procedures and be able to help you understand how you will be able to train everybody to follow them. Remember, there are two officials that need to be appointed within your organization. If you're subject to HIPAA, you're going to have to appoint a privacy officer to handle all the privacy elements that we talked about before, but also a security officer who then is going to be basically the figurehead, if you will, over everything that has to do with complying with the HIPAA security rule. And they're going to have to update procedures and safeguards. They're going to have to run through this checklist on a regular basis to ensure that all employees that have access to EPHI only do so as their duties or job functions would require, and that nobody else has access. So if you've got folks in your HR department who are working with the group health plan, and you've got other folks that don't work with the group health plan at all, and again, that's why we say it's going to vary by organization. You know, some of you are going to say, well, I got one HR person and he or she does everything. That's different than a larger organization that may separate tasks and may be able to wall certain people off from having any chance of getting access to any of this. Again, you have to be cautious and make sure you implement procedures to deal with any threat or security incident that identifies, where a breach may have occurred and addresses that under the rules, limiting access to your facility, putting rules around using your workstation, remembering that, again, devices, everyone's got devices now. You've got a lot of things that may be company or issued, but they don't reside within your facility, especially during COVID, especially as we work in the world in which we now work. You've got all this potential out there that all needs to be identified, and you need to make sure that you've got proper monitoring and proper control for the removal of hardware, electronic media, so on and so forth, as it's coming in and out of your facility, or as it's in somebody's home because they're working fully remotely. Again, setting up protections to control the access to your systems so that only those people or software that have been granted the rights to get to where the EPHI is. That's a very important component of what the security officer is going to do in making sure that you've done a proper risk assessment and therefore then can show that you understand and have complied with your security rule obligations. And again, that also would have to do with how data gets transmitted, and you have to guard against unauthorized access, usually by means of encryption. And there are certain standards, again, that your IT folks are going to be familiar with, and certain, again, I'll call them standards that are out there that if you follow along those guidelines, your IT folks will be able to ensure that you're working properly to limit access and secure any transmissions that contain PHI. The biggest threat, what is a breach? We mentioned earlier that there's breach notification rules are now built into the HIPAA security rules. And basically, again, a breach as defined by HIPAA is any unauthorized acquiring, accessing, using, or disclosing unsecured PHI in some form or fashion not allowed by the privacy rule that compromises the security and privacy of an individual's PHI. If it's unsecure, then you have a problem. And PHI is defined to be unsecure if it is not rendered unusable, unreadable, or indecipherable to unauthorized individuals through the use of a technology or methodology approved by the HHS. There's a presumption in this context that you have a reportable breach, unless the plan can demonstrate that there's a low probability that PHI has been compromised based on performing a risk assessment. And we're going to walk through a little bit about that analysis right there. The risk assessment has to consider at least 4 factors to determine the probability of a compromise of unsecured PHI. What's the nature and extent of the PHI involved? Who is the unauthorized person who used it or to whom the disclosure was made? Whether that PHI was actually acquired or viewed, and the extent to which the risk can be mitigated, that information would get beyond that unauthorized individual or be disseminated out beyond that point. If looking at all those 4 factors, there's a low probability of compromise, then you don't have to report that breach. But that risk assessment and that process needs to be documented. And ultimately, the plan sponsor is going to have the burden of proof if their decision is questioned at some point later by OCR or by a state attorney general. And that's why it's important to have a breach procedure in place. And that's why it's important to make sure that everybody understands how to protect this information to avoid the potential, again, that there is a breach. And that's why it's important to have IT involved, because they're going to be sort of the front line and making sure that all of this stuff stays safeguarded. All right, all unauthorized acquisition, access, use, or disclosure of PHI has to be reported to the privacy official immediately. So within your organization, if you get wind of something that has happened that would violate the rule, you need to tell the privacy official. That individual then can undertake, by means of going through that process we just talked about, whether or not notice needs to be given to the individual affected by that, or to Health and Human Services, or to the public media, because again, there's sort of a sliding scale on this. If there is a breach, each individual whose PHI was breached needs to be notified no later than 60 days after discovering that that information has been breached. The media would need to be notified if more than 500 affected individuals in one state. So a larger organization that discovers that all of its information related to all of its participants has been breached would need to make that known to a prominent media outlet where they do business. Also, there's an immediate notification of any breach involving 500 or more individuals, and an annual notification for breaches involving less than 500. And that is information that needs to be reported directly to Health and Human Services. Who else has to provide a notice other than the plan sponsor? Well, a business associate needs to notify the group health plan or other covered entity to whom it provides services when they become aware of a breach. And your business associate agreement, which we talked about earlier, needs to have a requirement within it that they notify the plan within a specific period of time and notify individuals and pay the cost associated with breaches. So that needs to be in the BAA, and your BAA needs to require that it be in any other business associate agreement downstream with any subcontractor that they have. Why do we care? Well, there's pretty hefty penalties for this, and penalties on a per violation basis can range from $127 all the way up to $63,973 currently, depending on whether or not the plan had no knowledge, or it was a failure due to reasonable cause, or it was a failure due to willful neglect. So it's a sliding scale where they'll look at all the facts and circumstances, figure out what went wrong, and assess a penalty based on the level of knowledge, the level of neglect. Most failures violate more than one requirement. The maximum penalty for all violations of a single requirement is currently just south of $2 million. Although in April 2019, OCR did exercise its enforcement discretion. So now penalties can range from a max of $25,000, which is far less than the statutory max of almost $64,000, up to the max penalty. And again, that's all going to be depending on the knowledge, reasonable cause, or willful neglect. There can be individual penalties on certain folks who cause these rules to be violated. And in certain circumstances, there's criminal penalties, that can be associated with this, which would include fines and imprisonment. The government has really started to crack down on this. Over the years, they've looked at more than now 200,000 HIPAA complaints. They've initiated now more than 1,000 compliance reviews, and they've settled now over 100 cases totaling about $1.3 million on some figures that I just saw recently. A lot of the focus has been on hospitals and private practices and physicians historically, but they are turning more attention to group health plans. We are starting to see more stories in the news of entities where somebody from a group health plan, for example, went home with a laptop in the backseat of their car, went to a restaurant for dinner, forgot the laptop was there, and then that laptop got in the wrong hands. And we're starting to see more of that type of problem rising up, and more OCR focus on group health plans. So certainly, while it may not historically have been the case, it is becoming more so. Remember, again, real quickly, I know we're at our time limit. But don't forget state privacy laws. Just because you're buttoned down from a HIPAA standpoint, there are states, California being one of them, for example. Many of the states have some form, and I guess all 50 states now have some kind of state level breach law that could be impacted. And again, just because you're complying with HIPAA doesn't necessarily mean that you wouldn't also have to comply with some other state level requirements. So again, as you're assessing what you need to do, remember that there are other laws that might apply. And finally, here in the last minute, what we call the big takeaway, which are the sort of the steps and things you need to make sure is you need to be able to recognize PHI. You need to only really store or save PHI that you need. And when we say you, we're talking about the group health plan. Secure any physical PHI under lock and key, whether that's locked in a desk drawer, locked in a cabinet somewhere. It should only be accessed by those who have a need to access it. They should be the only ones with key access to anything that's stored physically. Don't keep copies of anything like an EOB or any kind of other health statement from an enrollment application, for example. If you get any information in on somebody via some kind of an assessment, that shouldn't be kept around. Shred documents with sensitive information if it's been saved electronically. Sensitive employee information from any source should never be shared other than for a valid business reason and other than pursuant to your policies and procedures that control that and in a method that ensures that it's going to be protective. And finally, last slide, don't include sensitive information in the email subject line. Make sure that it's only in the body of the email. Make sure that the emails are transmitted always securely and in an encrypted format. Don't send, emails with sensitive information, through something that can't or doesn't encrypt the emails. Secure your phones, laptops, and tablets. Make sure that you have password policies in place. Those passwords are updated at regular intervals. Make sure that you have the ability to remotely disable a device and locate devices in order to be able to prevent against some of these disclosures. Always refer folks back to the company handbook for the rules that protect the company's systems and electronic information. And like everything else these days, if you see something, say something. So again, that's it in a nutshell. It's a lot of information. I know it's very important to understand your obligations, but I think if you work through and use this as a reference, it'll give you a good handle on what you need to worry about with both the privacy and security rule. With that, Frasier, I'm going to turn it back over to you.
Thank you so much, Carl.